to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends, live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Baker and friends, it's second to none.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what, if any, you might be. Valhalla is late. So good thing that my jury duty ended at noon. I was a little afraid that I couldn't make it, but Valhalla was ready to take over. Well, it's 8 a.m., 9 a.m., something a.m. Who could get up at that hour? No, it's fine. Valhalla is like a wizard, Harry. He's never late. But welcome all of you viewers over on Valhalla's channel. He will be here as soon as his beauty sleep has ended. Until then, I will hold your hand, take you through day one in emotion, hearing extravaganza. I think since last week we are 50 plus new motions. Most of, well, not most of it, but some of it is just the normal stuff. There'll only be one court cam, only one still photographer. I know some people read that and said, oh my God, they are hindering the First Amendment. No, it's the same as in most every case. There is a feed that they provide. They so that's normal. The only thing I read yesterday that they had a motion to extend the anti-First Amendment zone, and they put in there that the police should be able to use reasonable physical force to make sure people followed the rules. I thought that's weird to put in there, but because isn't the police given that right automatically, that if people don't follow what they tell them, they can say, well, in Denmark we say, klokken er mange, du er taget til fange. It's late, you are apprehended. But that was such a weird thing. Hanky Panky allegedly claims that the Arca guys lied. That's going to be interesting. He filed motions that all of the demands he has for the defense witnesses doesn't has to be fulfilled by his own witnesses because they are qualified. So you don't have to look at their qualifications because Hanky Panky says they are the qualifiest of the qualified. And he's a special prosecutor, so he knows. Yes, we will be talking about all the good results in the Danish Formula 1 team had. That's done now. When does the case start? April 1st. They need to get through a lot of stuff. No, they need to get through, I think, at some point we were talking about it, Jemima and I, and she might correct me, but I'm thinking we have more than 30, maybe even more than 40 outstanding motions. So if Bev is going to do Bever Clock today, or Claw Clock, as it's known, then we're not going to get through it. And then we're going to get extra days. And we have... we have 2 weeks, then the court is gonna, the trial is gonna start, because it starts April 1st, hard deadline, April 1st. At this point, with the amount of motions they have been able to get through on her previous motion hearing days, I'll be surprised if, because again, there's the Commonwealth still find new evidence all the time. So yeah, I don't know. I am doing fine. I was in court today and I was fine. So can the Arca guys file suit for defamation based on their accusations? Not worth the hassle. It's going to cost more than they can ever get back, because there's no... defamation is just what it is. He's not going to pay anything for it. If they go to trial with all this outstanding and just doing it during trial, always work. Hey, they found videos during the last trial. It's not like... Bev is... she's capable of running a courtroom with a lot of changing things going on. She's highly capable as a judge. I love that the very first day when she had demanded they put numerals on every piece of evidence, she changed that rule because she couldn't keep up. So unless she really gets her it together today, it's going to be hell. I saw two motions she filed that she allowed. What about Aiden? Are they going to raise a stink? Is he going to raise a stink that he can't be there as a reporter because he's been put on the witness list? There's so many things outstanding that it could be a problem. Yeah, April 1st is so appropriate. Yeah, they weren't... It's just a reputation that's damaged, so... He alleges in one of the findings, I haven't read that finding, I don't know where people saw it, that they withhold information from the Commonwealth. That's probably something he might need to correct the record on. And he claims they didn't put in evidence, all the evidence, so they left out parts that would have benefited the Commonwealth. But that's because Lally didn't turn over that evidence till after the report was written. So now the Arca guys are helping the defense because the Commonwealth didn't disclose their evidence. I'm not sure. And I've said it before, and people are saying, no, it's not. My speculation in this case is the Commonwealth ain't playing on the same team. I think they are hamstringing the Special Prosecutor Beeman all the time, because he files motions that makes no sense if you were part of the first trial. She needs a Coca-Cola Classic from Elon. I think she needs a drip with some White Claw in it. That's probably more her style. And we know she's going to run out of energy in... well, before noon, and then she's going to be Can we move on? Thank you. And he want to roll in Aiden's charges for witness intimidation in the anti-First Amendment zone into the case to claim that they need a bigger zone. But he hasn't been found guilty in that as allegations, and that's such a BS thing. Because how can you use all of these things when nothing goes through the courtroom? You can just keep everyone charged with everything, so you can use it as an excuse. Excuses is also something this guy had.
Always got excuses. Always.
Sorry we started on time.
I was telling everybody, you do this to me. You tell me 9, and then you schedule it for 8:55, and then you start at 8:45.
I schedule it for 8:50, and then I play my intro with 1 minute and 33 seconds, so it's 8:50.
On the dot.
I've been doing this for a while. Good morning, my half-baked muffins. Thank you, Shore Life, for being a member for 6 months.
Nice. Hey, Shore Life.
Oh yeah, Aiden is being arraigned in court today at noon for yelling at a TV camera that shouldn't be able to capture his sound. When are the charges coming against Chris Albert for illegally wiretapping?
Well, we know that's not going to happen, Baker.
No.
He's got a badge. People with badges don't commit crimes in Canton.
Did something bad happen in Tennessee?
It got cold.
The expert is up before noon.
Oh, that's true. You okay, buddy? You need me to come over there and help somehow?
Yeah, he must have a water leak or something.
His house flooded. It's like 32 degrees right now. It's terrible.
We started out this morning. My car was covered in the white frost, just not frozen, but that layer. And I thought, well, I have to get ready early for court then. Then I went out 30 minutes later. It's gone. Perfect weather. Beautiful sunshine. Went to court. And then it looked like it was going to rain. And then my stupid neighbor started calling me, and I can see it on my watch, and I was like, normally it's just something really, really dumb. Then he sent me a text message that he wanted to bring into the attention of the homeowners association that out on this side I have a fence, and there's some boards on the bottom that's broken, and he had just put up some boards in front of it because leaves blow in. And I was kind of like, yeah, I might just chuck the rest of them off so I can get some light in out there. So he now wants me to replace them. And I'm going to do it, no problem. But he wanted to take it to the homeowners association, forgetting that fence was put up by the owner before my dad without permission from the homeowners association. I was like, he built an entire, like a covered terrace on that side, which is illegal because you can't build that much on these small lots. So I was like, yeah, I could just call homeowner association and say, could we just pull down all the shit he built on his ground? But nah, I'm a nice guy.
Why would he go straight to the HOA? Why wouldn't he be like, hey man, can we fix this so I don't got to clean up all these leaves?
Leaf blows into his at where his partition is because he has put up a door. If he didn't put up that door, it would just blow through down to the other end and no problem. But now it's my problem because he did that.
Yeah, there's no way you could get me to live in an HOA. There's no way.
I'll never get people's obsession with ordering leaves. And again, he runs around with a leaf blower. And it's not like if it gets a bit much and okay, there's leaves out there, I'll just take my broom and just make them disappear. But I'm not going out there every day to take if there's 30 leaves out there.
That's crazy.
But it's just, why not just, well, I've been coming by a few days, but you're never home. I'm home every effing day. I'm going to write the homeowner associations demanding that no one throws out trash at 3 in the morning, because he does that all the time and slams the lid.
Baker's got a neighbor dispute, y'all.
Yeah, but it's that petty shit. I was just about to go home, take a crowbar, and just rip all of it off and say, well, I don't have any money. I can't buy the flagpole. Is it a different angle today?
I got an email from Michael saying what the name's
Lenny, my bald friend.
Maybe slightly. It looks like it might be over to the right more.
Yeah, don't you normally see the defense team a little from the front?
From the back, you mean?
No, a little more. So we get. If you take the microphone in the middle, I think they're normally one microphone up. Let her talk to her dad without
Why?
zooming in.
Why? God bless it, man. Busted.
Yeah.
That's what you get, cameraman. Or woman. I don't really know.
Person.
There you go. Camera person.
Camera person. Went to my cousin's yesterday and they have cameras. I parked in the driveway. As soon as I got out of my car, the recording announced, "Your voice is now being recorded." Yeah.
That's fancy.
If Valhalla offers advice on when your child will be born or when to file taxes or anything to do with deadlines, perhaps consider alternative counsel.
She's going to have the baby. The baby goat is coming. Just a matter of when.
Do you watch Clarkson's Farm on Prime?
No.
It's that guy, Jeremy Clarkson, who used to have Top Gear.
Oh, yeah.
He bought a farm, and then the guy who took care of the lands stopped, and it was right before COVID, and he thought, well, Top Gear's done, the other one we did for Amazon's done, so I'll go home and try to be a farmer. A really, really great show, because it shows it's really hard to be a farmer.
Yeah, it's
especially
not the easiest thing.
Especially when you buy the biggest Lamborghini tractor you can that can't fit into, because every British field is made for normal-sized tractors. But he had pigs. He bought pigs, some old British pigs, really, actually quite cute, some spotted ones, and it was so heart-wrenching to see, because pigs are really bad parents.
They can be, yeah. They're really protective, but they occasionally will squish their babies.
They squished like half of them.
Yeah, that's so. Like in the big breeding pig farms, they have like these special stalls built so the moms have to stand up all the time and the babies can run underneath them. But it's designed so that the pigs don't get squished.
Yeah, and he had like an igloo they could be in, and then he actually reached out to them and said, "Could we get like a bar so that mom couldn't?" Because she wanted to lay up across and feel the wall, and then she'll just squish the baby. But that's not the thing. One of those pigs was inseminated and never gave birth, so they perished inside of her, and that was quite horrible.
Yeah,
it's a really good show, because you really get to feel that there's a lot of joy when the weather's good and you're walking around, but there's so much hardship in being a farmer, especially if you want to live off farming.
Yeah, well, I can't live off farming. Like, I'm not doing that. You know what I mean? No, not intentionally. Not intentionally.
Hear ye. All persons have any business before the honorable.
Hear ye.
Justice of the Norfolk Superior Court in County of Norfolk. Draw near, give your attendance, and shall be heard. I take the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed. Can counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Adam Miley for the
Good
Commonwealth.
morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Giannetti. All right, so we have a lot to cover, but what I'm going to start with is
Let's take a break.
a decision on the Commonwealth's motion to exclude employees of ARCA. So, I think I told counsel before that I had reviewed, so first we had full hearing from counsel. I heard from the lawyers, I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts, I've listened to the sidebar conference and read that transcript, and I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the
Jesus
court by
effing
defense
Christ.
counsel, and I conclude
counsel?
that they were deliberate concerning the relationship with the ARCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. Yet, on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court. So, I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations, and before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So.
That's amazing.
Well,
That's amazing.
Will she keep the Commonwealth to the same standard now?
She better. I mean, the Commonwealth has obviously been more blatantly misrepresentative than the defense has, in my opinion. And I can't. I'm flabbergasted. The amount that Brennan's been
Lally
lying
misrepresented constantly his contact with the lab during the first trial, or the lead into the first trial. No problem. And the payment happened after the trial. This
I'm flabbergasted, Baker.
Yeah. Then all the videos should be out now. All her videos should be thrown out.
They're still getting videos. We've done a whole trial, and they're still getting new discovery videos. I
Lally,
just don't understand.
Lally
I
will
don't
be
understand.
sanctioned now. Well, Brennan and Lally will then now be sanctioned because Proctor withheld evidence, and they lied about it because they certified that they had turned over every piece of evidence. Because Brady attaches to the team, not the person.
Not in Canton. Not in Canton.
Yeah, she's gonna yeet Jackson, something like that. This is absolutely crazy. That this is because they didn't misrepresent. Because they talked about having contact with them beforehand. All they had was an email saying, "Yeah, you can say whatever you want." And now she.
I don't understand how she could possibly get up there and say this with a straight face.
Is this grounds for appeal? Well, you don't want an appeal.
That's the problem, right? Like anything is a ground for an appeal, whether it's a valid reason or not. But that means you lost, right? Like that means you're already starting in a hole, and you really don't want to do that.
If she's yeeting the ARCA guys, I don't know if they can appeal that and say we should be able to bring in this witness and then have the case postponed until there was a finding on the matter. But her coming in and claiming that they've been misled, I really can't. Well,
wow.
This is the first surprise of the day.
All right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a matter, Your Honor.
Okay, so because Mr. Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be by himself. All right. But Ms. Reed...
What? Are you threatening them now to take his pro hoc vice even? You tossed Betterow, and now you wanted to... You just said she has the right to a fair trial. Go F yourself.
Does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So, based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential.
Are you going to remind Brennan of that? He lied to you to your open face, and you just said, okay, I'll allow it.
It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So, I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time.
This lady is off her rocker.
Commonwealth, I am denying your motion to exclude the ARCA witnesses.
Good.
Those witnesses can testify.
Of course they can.
As long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to Mr. Lessie. You didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor.
Wow.
May it please the court. The proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to
She wanted to scold them on camera. Exactly. That's all she wanted. Remember, this argument came when Beeman, Special Prosecutor, lied about obtaining evidence from the feds. A liar is only as good as his word.
demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Dalbert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death, as opposed to causation, his cause of death, you need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak.
Please put in some signs so it's not too clear what you're saying.
Specific, because he's got to be able to show both, because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, 1 paragraph. And the applicable aspects of that paragraph is he says the following: based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism. Mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it, but the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently does. So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death, he states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record that he is qualified. It's not enough to say you're a neurologist and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scorti-Bello. Dr. Stonebridge didn't even venture into the manner of death at all, didn't comment on it. Dr. Scorti-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury. So in terms of the paragraph that I was just citing in his findings, it says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Where is the support that Mr. O'Keefe fell backwards? A neurologist can't determine that is a manner of death. He provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that? And it's also not in the autopsy. And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a podologist, you need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident, so there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dalbert-Lanigan factors. So in terms of both prongs, Dr. Wolf fails because the Commonwealth has not even begun to meet its burden. I would like to also reference what we just received last night, which is an article that was co-authored by Dr. Wolf. And I want to note and this is Fractures of the Classification and Clinical Features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolf, mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta-study. They went back and looked at a lot of data and information. But it says, under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his one-paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this study talks about mechanisms of injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury, and that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries? So this study doesn't at all, one, support any methodology, number one. It doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points. Dr. Wolf says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy. And we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts. It's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner, he's not a forensic pathologist, he has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article, and I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin, and in the alternative, we would request an evidentiary hearing, because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman, it's the same with other experts, where there is no statement of the methodology, as here, there's none, and there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the 2 prongs of the Daubert inquiry?
Just to catch up on a few things that I said. Over on your channel, the start of the super chats to have a goat named Scandi. I may have to triple that for the goat food.
There's no N in that word. It's Scotty.
No. because I don't want to be read as the Norwegian girl goddess Skade. And Sue clearly owes the swear jar. You do, Sue. Mr. Reed and Nathan Reed are on the Commonwealth witness list. Can they be in the courtroom before their testimony? If Bev will grant them, if she'll allow them to be there, she would have to grant them the right to be there.
Aiden's standing right there too.
Yeah, but it's not been ruled on yet, and court hasn't started. So she can't chuck them out, but she allowed them in the courtroom for the last one. So all of that was just to threaten the defense counsel. Yes, it was just to yell at defense counsel and give Karen Reed the option to throw Alan Jackson off of her team. Huffing and puffing, that's because I think she knows she overreacted when she ended that motions hearing early, and she just wanted to have a big blow-off. The same motion was started by a lie from Brennan, and she hasn't said anything. He just corrected the record. And I heard she's not removing Arca and Jackson, but not what the sanctions are. The sanctions are nothing.
Well, she said she hadn't decided yet, so she might still do something, but that's what she's come up with so far.
Yeah, she sounded a little bit about, she might touch the Pro Hawk Reacher, and then she said, I'm not going to touch the Pro Hawk Reacher. But she could do sanctions. She could, I don't know if she could give them a fine or something. But as long as he's not losing his Pro Hawk Reacher, then it's a nothing burger.
All right. Thank you. Mr. Brennan?
Let's hear his BS now, because it's going to be other BS. Yeah.
May I?
Please.
Attorney Leslie mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon.
It's still not a forensic.
In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4.
None of this has to do with
principal investigator, exam treatment of brain tissue.
No.
Acidosis in severely injured patients. Principal investigator, PEG, SOD, and severe head injury. Improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways list 16, many of them dealing specifically with head injury and brain injury. His book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries. Intracranial pressure, number 2 on his journal articles. Initial management of brain and spinal cord injuries, number 9. Number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16. Fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles. His presentations, specifically on fractures, basal type injuries, number 5 on page 13. Number 9, neurosurgical management of traumatic brain injury.
Why does this matter?
All of which is what happened after the injury occurred.
Right.
Something happened and I took care of the byproduct. I don't know how it happened. That's not my job because I'm not a biomechanic engineer. I'm not a doctor. Well, he is a doctor, but he's not a pathologist. He has no knowledge of, well, he hit his head on the ground because he doesn't even know how hard the ground was. This, again, it's just bullshit and she's going to allow it in. Even though Dr. Russell had to sit through 3 days in court with 20 years of experience.
None of this has anything to do with what Alessi said. Alessi said that this guy can't make the assumptions that the Commonwealth is trying to get him to make. And Commonwealth gets up and like, but he's so accredited. He's been doing this for so long. He's been published. What's that got to do with the argument at hand, Brennan? Nothing. Nothing.
Yeah, he can explain what the injury did to his brain and how it contributed to his death, but he can't say that how it occurred.
Number 10, acute head injury, and the list goes on. Over 90 references. Lectures and meetings, many of them dealing with head injuries. Over 100 lectures listed for reference, actually over 130, and a number of web publications. So this neurosurgeon, who has this extraordinary experience, is qualified.
Because you say so?
The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead.
Are you an idiot?
What did he just say?
Are you an idiot? An oncologist and a knee surgeon are two very different types of people. They have two very different types of skill sets. An oncologist is way better at treating cancer than a knee surgeon.
He basically just ripped into his own medical examiner, the Commonwealth's own witness, the ME, the one that's in charge of all of the Commonwealth's cases when it comes to a death of a person. He was like, yeah, this guy's better. This guy's way better than her. Don't worry about what she said. Oh my God, Brennan.
I'm gonna need to go buy me a pack of cigarettes and start smoking because this is infuriating stupid. When he's against the defense witnesses, he argues that they don't have the expertise needed in that specific area. And then he says, well, you don't need to have specialized experience because as long as you've just seen a brain before, you can extrapolate everything from that as, there's some injury to your left temple. Well, you must have been in a bike accident.
It's far superior to any pathologist. Far superior. What a
Can we request a hearing where Beeman doesn't get to speak at all? This guy makes my skin crawl. Sadly not, Carly. You're going to listen to him for 8 weeks.
This guy is something else.
If a patient is unalived, you can't make him better than when he came to you. True that.
Dr. Wolf treats patients that are in trauma, who some survive and many die. So he is intimately familiar, not just with looking at a deceased in a lab. He's intimately familiar with assessing the injuries after they occur. Diagnosing what the injury is.
He's qualified in assessing the damage to the brain. It's
He can say that there's a broken leg. He can't say that you fell out of a tree to break the leg without knowing that, right? Like
if
that's
no
not
one
how this
you...
works.
And an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as countercoup.
Through his teeth.
And I dare say the defense proposed expert, Dr. LaPosada, is not in disagreement with that. To understand countercoup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have.
It could only hit. You could only hit your head to the ground because there's not enough force, as much force as if you swung a bat. But I can swing a bat at different speeds, which multiplies or decreases the force. And he doesn't know because he can't tell because he's not an expert in biomechanics.
This is the first time he gets behind the podium, and I already need a bio break. Like, this is unbelievable.
The same level of experience and didn't diagnose it, but this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. LaPosada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with countercoup, having treated tens of thousands of patients, and he understands in countercoup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history.
Remember your methodology.
Can't be that his ultimate conclusions of countercoup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth, but we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
All right, thank you. Mr. Miller, say anything final?
Yes, thank you, Your Honor. Mr. President. Thank you. Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Daubert factors. And that is the fatal aspect of Dr. Wolf's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit his testimony to cause of death, not manner of death, because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? It takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025. Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney Brennan concedes it by his own words. He said cause of injury. And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolf, and it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Daubert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the record that's presented, including the CV, etc., there's not one instance where we see that Dr. Wolf has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Okay. Do you want to respond at all, Mr. Brennan?
Thank you, Marissa, for being a member for 15 months and saying, hey, Brandon, look here at that shiny member chat.
At some point, arguments become semantical and theoretical, but not practical. This doctor has treated thousands and thousands of patients, many, unfortunately, which have died. And as a neurosurgeon, engaging in the operations and the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them.
That's not obvious.
So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades.
You have to describe his methodology,
Share this real quick. Just real quick. It's exactly what we're looking for right here. That's not how this works. That's not how any of this works. You're an idiot, Brennan. You're an absolute idiot.
I can't show you how he knows. I just know he knows because I say so.
Thank you, Stingy. Yeah, that's what he's saying. Trust me, brah. Trust me.
And he is the guy who yells at every defense witness that they don't have methodology. Here, we don't need methodology because he has experience. More than Dr. Russell, you big idiot.
Of experience, seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alisi, but that is so unnecessary because it's obvious. Thank you.
Oh, he could. Okay. He could present the reasoning, but he's not gonna. It's obvious.
I could have made an affidavit saying this is his experience. He had done this 20,000 times before, but I thought, Judge, just look at his CV. It's no problem. Who needs a Daubert Lanigan hearing for any experts? Come on now, Judge.
Thank you. All right, so we have a series of motions in limine. I'm going to start with defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the defense on this motion.
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It looks like...
We attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence.
Did she adopt it? Was there... Okay.
She did indicate, and that's part of my argument, Your Honor, which is...
So I'll go ahead. I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall...
So let me just have, so you're just trying to use it as a chalk, not an exhibit?
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
Would be a partial objection to a chalk, some of the labeling. I have less concern with a chalk as I do an exhibit.
And so we can take it in two steps. I certainly don't need to decide now whether it's a...
It's a presentation to kind of say, okay...
like a demonstrative, basically.
Yeah, demonstrative. It's just, they call it chalk. So it's... I think this is the tail light where they made this part was found here, this part was found here, this part was found there. And they showed it to her the last time, and she said, yes, that's correct. And they now want to use it again, and then want to send it back with the juror because it's hard to understand all these little pieces of evidence where they came from. But they don't want them to have that from the Commonwealth because you have seen that lots of times where you can see Proctor found all of these pieces, Hanky Panky found not Hanky Panky, Bukaki or whoever found all of these pieces. I can't pull it up because I have to take the other screen off, so that's why it's. Oh, can I remove this and do this? Yeah, I can do this. It's like I believe it's this one, and if you look at that and see, funny they only found that little piece in the middle from the third team. All the big pieces wasn't found until way later. So that's why the defense doesn't, the state doesn't want it to be introduced.
Admissible, and I couldn't. But what's the nature?
Henley.
Is this something?
The court will call this. This deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass, there were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time,
no,
right?
This is more attended to the glass in the bumper.
Okay.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
These were a bunch of pieces of glass that were that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple.
So it's not the tail light; it's all the glass found at the scene.
Sources and different and distinct between and among each other. We reduced the very complex, the court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
do you have the day of her testimony?
Oh gosh.
Ms. Little, do you have that transcript pulled up?
Yes, one moment.
Is Miss Little a paralegal? Come on now.
She is.
Obviously, I remember.
She is Bev's specific intern. She's there strictly to provide Bev with what she needs at any given moment.
Yes, Zach. I think so.
Don't do that.
Don't take this as medical advice.
Don't do that.
I remember testifying. I remember seeing this previously.
Okay. June 5th, 2024, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her on the witness stand, and she did adopt it, and she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence. What matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll ask for its submission at the right time.
All right. What's the objection, Mr. Brennan?
I don't like it.
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there. But also, it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case, and I say that because we learned last night, for the first time on a public hearing of an episode, that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that, and also there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony, or statement rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important, but looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
Okay. All right, so Mr. Jackson, what I'm going to do is just hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. I need to hear more of the evidence again.
I understand.
And I'm going to read the transcript, so that will help me with
I
this.
think it makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day. It's Ms. Hanley. So I do think that if the court would keep an open mind,
sure,
Ms. Hanley testifies, then that would be the appropriate sign.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
I'm open to working with them if there's something they want to explain.
All right.
No, you're not, because you have done nothing but claim you have been open to do everything with the defense, and then you have kneecapped them every time because you are a lying liar who lies while lying.
Great, thank you. All right, so no action taken on paper 558. So one question, the next
Shocking,
motion
she
I
didn't make
have
a
is defendant's
decision.
motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. The Commonwealth has a sort of maybe a similar one that I'm not sure. The Commonwealth's motion.
As I understood her, at least as a chalk, they will be allowed to use it potentially. But they probably really want the chalk to be brought into the jury room so they can understand that it doesn't make sense.
Eliminate to admit the victims out of court
taillight picture, though.
Yeah, I think it's the tail light they call glass as well.
Yeah.
Statement relating to a state of mind. So the Commonwealth's Binns and Qualls motion, does that address the Aruba witnesses? I'm just wondering if they're hand in hand. So the paper number on the Commonwealth is 585. It's got your 11 on it, though.
No blue shirt today?
So the defendant's motion to eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the, let's just say, the Aruba witnesses. I don't, Marietta Sullivan, Laura Sullivan. Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children as well?
This does not. This is limited. This argument will be limited to the, we'll call it the Aruba incident.
Okay. All right. So given that, that might not include the Commonwealth's number 11, the Qualls, Binns, the defendant's statement.
No. She didn't remove ARCA, and ARCA is with two C's. But they are allowed in, but she was scolding the defense. But ARCA is allowed.
The victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
How should we know, Marissa? You're sitting next to her. I'm 6,500 miles away.
I don't even know where you are, Marissa. How am I supposed to know who's next to you?
Anyone who has eyes on Marissa can tell if the lady next to her is a free cam reader.
Love you,
Oh,
Marissa.
she's been in our chat too. Tell everyone in court that you get the best trial coverage on The Broken Baker or Valhalla Awaits. True crime, box wine, in
And
bed
goats.
by 9.
The defendant,
So I didn't mean to interrupt, Mr. Brennan. Do you want to?
I just want to know if that is part of the Aruba one.
okay. So our statements relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We
Okay.
do not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door,
They don't.
then we may proceed with it, but in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay. There we go. All right. All right. So, Mr. Brennan, you can have a seat again, and we'll go through the defendant's ones. That's very helpful. So I will endorse it as Commonwealth does not intend to introduce in its case in chief. If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood, thank
All
you.
right.
Aruba.
All right, so that was 5:59.
Started out really, really bad. Then Hank started talking and we lost our mind. And now Aruba won't be a thing. So it's been a day of...
The defendant's motion eliminated for review. Is the Commonwealth seeking a view as well?
We did not move for review, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I am, Your Honor.
Okay, so what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view.
Okay.
Okay, but let's talk about your client attending it.
Yes, Your Honor. There was a request in there for Ms. Reed to attend. That is something that's allowed under the law.
How do you propose that's done?
If it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus, if the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that.
Commonwealth put it there the last
totally
time.
different lighting conditions, timing conditions, and I think it can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine, would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposal. So I need more information from both. So, Mr. Brennan, I'd like you to come up with the proposal about viewing the car a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place. If that's what we decide, we may have to do it all at once.
I do think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes,
Absolutely.
it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right, so let's try and figure out some of the particulars. I would like to have Ms. Reed be able to attend, so let's figure out some particulars. All right, so defendant's motion eliminated to exclude certain witnesses before and after testimony. That's 462, and I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562, did I say 4? Sorry, 562. 576. So, Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this...
If they did, that would be towed, because nothing would be allowed at a viewing of a crime scene. So don't do that if you don't want to lose your car.
Court issue an order for sequestration in keeping with what the Commonwealth also requested.
Someone lay on the...
But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes.
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know. She was, or he or she was anonymous.
Okay.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their...
All right, so obviously is not something that should be in a motion, okay? If you've got an agreement that each other's experts can be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted, okay?
I just wanted to make sure that that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, and I won't speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right, so you all need to talk, all right? And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given, okay? All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned about after the evidence is closed.
Don't tell him what you think about it.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the
Time-honored
closing.
tradition.
The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name Higgins, Albert, they invoke those names, they characterize third-party culprit, and they suggest that some anonymous person was uncomfortable.
Juror, not a person, an
It
anonymous
seems as
juror.
though the presentation has a deliberate point to promote a cause, but it doesn't have any sense of balance or fairness whatsoever.
It has a very big balance of fairness, you idiot.
I
Remember,
hate this guy so much.
I don't know
Oh
if you
my
can
God.
see right here. You can see the shoulder of a guy that I believe it was at the last motion hearing, claimed shouldn't be anywhere near the courtroom. And I think you have a motion you put him on the witness list because he threatened your witnesses. He is a scourge. You even mentioned it in your anti-First Amendment zone order that because of Aidan Carney and his intimidating witnesses, you should have a bigger zone. And now you're saying that a witness, not a witness, a juror who should be the most protected person in the courtroom, more than the judge, more than the lawyers, more than the defendant, a juror who is a non-party to the case, who is forced to be there, is just, go fuck yourself. You don't have any reason to feel intimidated when Brian Albert is sitting like this, staring at you.
Staring down the jury the entire time. Unbelievable.
So jurors should just suck it up. Yeah, I'm sure you're one of those lawyers who said, well, she did put on that short dress. Come on now.
I can't stand this guy. He's absolutely the most vile human being I've ever witnessed.
I remember Andrea said, well, that's just his way of...
Mm-hmm.
If he's been doing this for 20 years, someone should have had to talk to him and say, you better change your ways. Because now he is inferring that jurors should just suck it up and don't feel intimidated when a big guy is sitting like this. I'm pretty sure if I sat in the room right next to him and just looked at him, making sure that I took my arms up so I looked even bigger, he would feel a little bit discomfort.
I would. Baker's big, y'all.
Yeah, I'm fat, I know.
All witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government, and certainly I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in a courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair. It's just.
They are not family members. They are witnesses. They are not family members. They are not there to support the O'Keefe family. They didn't know the O'Keefe family. And now you're saying they're there to support them.
It's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rests and during a closing.
It's a family.
Not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I actually deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may or even if they do become witnesses.
Okay.
Your Honor, if I could address one issue.
Sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective order, but I would like to make a record.
Next one might have been yours. I'll take a closer look at both of these and have something later. All right, so Ms. Giannetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
That's also mine, Your Honor.
Okay.
I believe the Commonwealth has indicated that they will agree to that.
Okay. All right, so paper 565, allowed by agreement. So 566, defendant's motion for panel voir dire. Who's arguing that?
That's Your Honor.
Okay, so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but...
Could you shut up for 2 seconds? Every time AJ stands up, your mouth keeps moving.
Why don't you focus on panel voir dire for me?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa. personal beliefs about driving under the influence. We think that's attendant to this particular case. In particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime, and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights to.
Okay, we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys, would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to impanel a fairer and more comprehensive jury.
Okay, it's the Commonwealth's position.
Please do that. That's always a pleasure when you're sitting there thinking.
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument, in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or follow-up that's reasonable and necessary. And I understand that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely...
No, at least 3 things so far has been ordered by consent, but I didn't get what it is. I'm pretty sure that I have a mod who's already writing me in Discord. Why didn't you mention that it was this and this motion? Because I don't do homework.
We agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say on that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that. I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow, so I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire, but I want you to agree to it, and if you can't, I need that. You know, I need that by the end of today if you're not going to agree to it. Have you proposed a questionnaire? Both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we can act on to start with.
So let's do that.
He's answering your question, and he can't say 2 words before you're already sighing and interrupting him. Do you know why this has national and international media attention, you big O? I'm sad. I actually have to call my television provider because I don't have Max. I don't know if it's available in Denmark on Max. But the reason why this trial is so much in the media, why I sit with Valhalla and we have 168 combined viewers, which is probably the smallest channel covering this today. And we get thousands of views on these cases. It's because you are so heavily biased. The Commonwealth is so, I have to watch my words, so inept at having a trial. That's why it has all of this. This is why you can't see the jury, because you're running a shit court. I'm sorry, your lordship, but it's your fault. You made it into a spectacle.
Everybody that's watching this sees how ridiculous this is. That's why it's getting so much publicity. Everybody that's a court nerd, a law nerd, is watching this and just speechless with every decision made by the Commonwealth. It's absolutely absurd. It's absolutely absurd.
Yeah.
And what Mr. Brennan's new to the case, what I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in, and I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity. And we'll do extensive voir dire at sidebar and the questionnaire. So 566 then is denied because it's requesting panel voir dire. 567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So, is there an objection to that, Mr. Brennan?
There's not. I believe that rule should apply to both sides. I have no objection.
Okay. Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay. All right, so that, Mr. Clerk, 567 allowed as to both sides. $570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses. All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, "You know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it." In some way, shape, form, or fashion, she outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agree, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others, consider an unjust prosecution of an innocent person for a crime that she did not commit. There's an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed, very specifically, should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord, and they certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down of the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable cause
understand
standard,
that.
right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed...
When was that no bill issued?
You said when or where?
When?
I want to say March 23rd. March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believe, and I think what the court would have ruled, would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So the court did make that ruling, that ultimately if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be very easy.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to Ms. Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. In any event, I think the court understands what our concern is with regard to the subject matter. We don't want a free-for-all of people, one person after another walking into court and basically lambasting the defense for all intents and purposes about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me. It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But
Another
it is
trust me,
unfair
bro.
to stand up here at this podium
Trust me.
and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it.
By your husband.
And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note, okay?
Of course.
All right, go ahead, Mr.
I
Jackson.
just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses
AJ.
and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Miss Reed to Aiden Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said. At the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say, bash witnesses, use this as an opportunity to bash people. But we could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief, and we will be very mindful of what would conceivably open a door to this kind of testimony, and I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. We'll ask the court's guidance by coming to sidebar, and I think that could resolve the issue.
Okay, thank you. I'm going to look at this a little more closely. All right, the next one is paper 571, and the Commonwealth's corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth argue their make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to answer your question, the defense preference would be for the Commonwealth to go first, and we would respond, including with regard to my motion.
Okay, so Mr. Brennan, our paper 386, your number 12.
Did I miss anything good?
Yeah, kind of. What the hell's his name? Brennan started accusing Jackson of bashing witnesses, and Jackson was not having it. Made it very obvious that none of this was professional, and that this would be a much smoother process if Brennan wasn't up here hurling insults, talking about Turtle Boy's connection to Karen Reed and whatnot.
Oh. Well, he's an asshole.
Yeah, he is.
Your Honor, paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We've cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth v. Hallinan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right, now I'll hear you, Mr. Alessi.
Thank you, Your Honor. Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable, and here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So, with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up and ipsy-dixit in saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report.
I talked about it Sunday on the Andrea panel. that I think he has burned all the nice bridges. Him
I
and
think
Alessi seem to have had a pretty cordial relationship, but he burned those bridges with all his misstatements and all his lies. And
Yeah, I think the defense is about over his shit. I think they're done.
Yeah.
Of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states, 2 paragraphs under the chart, with an asterisk, the ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B, in terms of changing that conclusion and that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas, chromatography, or enzymatic. And we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
All right.
It should be excluded.
Okay. Do you want to respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay.
Can I just respond briefly?
Sure.
Thank you, Your Honor. Your Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay. I think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk?
So they wanted to have Richard Green, who had, I believe, some drunk driving or something on his record, pull that in. You know, you're really scraping the bottom of the barrel if that's what you want to do to discredit a witness. Especially if he have paid his fines, served his time, and it has nothing. Oh, a bar fight. Oh, yeah, that has everything to do with his testimony. Brennan, you're so out of that. If Bev had been any way non-biased, I'm not going to say not corrupt or anything like that because I have no proof of that, so I would never state that. But if she had been less biased, you could just fold up and go home.
right, so what I'll do is I'll see counsel at sidebar regarding scheduling.
Why are we having a scheduling conference in the middle of the motion hearing? Why are we doing that? We are here all day. You don't need a scheduling.
Maybe she's talking about lunch.
Maybe she's talking about, it's been going good. I think we can get the rest tomorrow. Mamas need a claw. Sun's out, claws out. The cougar's gonna plow.
That chicken parm at D&E's not getting any less mediocre.
And cameraman, remember that agreement that every time they are at sidebar or nothing goes on, you have to point the camera upwards. That's a motion filed by the Commonwealth. I believe Hank has to be over in Aiden's hearing later today for a motion he made for records. Yeah, but that's at noon, so he can waste his lunch break on that. It's to drown out
white noise.
anything, so that's the white noise machine. And I think it's the beep is just there to say, yeah, we still live. Jemima, should I go out and look for some Legos for some opening statement bingo? Do you want to make a bingo again? Probably gonna be, I don't know, when opening. It's probably be more than a week of just paneling the jury.
What are you doing, camera guy?
He's trying to catch. Look at that face. She's guilty. Now all the body language expert is gonna sit tonight and say, "Look at her. She's guilty." You can see it in the way she blanked.
He zoomed in on Aiden earlier too, when they were talking about all that nonsense.
I don't want anything. I know you want to do a lot of things. She's always asking me, should we do this and this? And I'm like, I don't do homework. I'm a grifter. Hey, Jerry. Should we put it to? It depends on if you wanna make the bingo charge, because I'm not doing anything.
Did you take a look at private chat by chance?
I can do it now.
Cool.
Normally I break because of the YouTube 4-hour thing. I wasn't thinking bingo for this one, lol. We talked about it doing trivia. I don't know what trivia is.
Trivia?
All rise for the court, please.
You are muted.
What have you missed because you had an hour workout class? Well, I hope it was a good workout class. The ARCA guys are allowed in, but defense was scolded for not being honest. She didn't do the same to Brennan. Dr. Wolf, defense claims he doesn't have the necessary skills to testify, and Hank says he's way better than a pathologist to determine the cause of death, even if he doesn't work in that field, and he can base everything on the brain injuries. No ruling on that one. Christina Hanley, she's the one who looked at all the glass at the scene. They wanted to have a chalk that they also put in as evidence. They they used the chalk the last time just to show to her, not to show to the jury. It's going to be a hold off. They talked about the prior bad acts with Aruba, and Commonwealth doesn't want to introduce the Aruba chicks in the case in chief, which I believe then they'll save them for rebuttal and get in. Well, she was a C word. The defense wanted Karen Reed to be able to participate at a view of Fairview 34 with the car. The defense didn't want the car to be at Fairview. The state didn't want the car to be at the scene. The defense wanted to show the proportion because apparently everyone who has been at Fairview 34 says it's deceptively small. When you see it on pictures, it seems way bigger than it is at that front yard. It's the same technique Zach uses to make it look bigger as well with the photography. So that's going to be interesting. I would really wish that we could, because again, if it really is that small as people say, they should be even more aware of it inside the house, what happened. Then we talked about keeping out the McCabe's because...
and Higgins.
And Higgins, yes, but because they were allowed in and sit and look at the jurors and they felt intimidated. Hanky Panky kind of underhandedly said jurors should just accept
being intimidated
being stared
by a
at.
cop.
Yeah, and not feel scared by Brian. She punted that as well. Then they wanted to have jury panels. That's where you have a full courtroom of 20 people that they ask questions of. But because of the media attention, she was afraid that that wouldn't be good. So they have to give her examples of jury questionnaires by today. And then there was something I didn't get where I have just read down. Brennan accusing Jackson of bashing witnesses and defense working with Turtle Boy, and Jackson's not having it. I'll go back and look at that later.
They were attempting to keep the harassment, quote unquote harassment of witnesses out. So Jen McCabe saying that Turtle Boy was harassing her was basically the crux of the situation.
Yeah.
And Bev she cited Alan Jackson's in the first trial as how that door got open. Alan Jackson disagreed with the court, said he didn't believe he got anywhere near the line. However, Bev said, read the transcripts. So they're trying to keep the harassment of witnesses out because it was unfair to Karen, who a grand jury found no connection of.
Yeah.
Yeah, that was that.
And as I said...
Also, sorry. Also, Karen Reed visiting the visit was today too, and it sounded like she is going to allow that, but they need the details steamrolled out.
And the blood draw, Brennan claims that defense used the wrong clauses that has nothing to do with it. And Alessi said Brennan again misrepresent what we are asking. And the Commonwealth has to prove that the testing is okay, not just by claiming it, which is ipso facto, that word in Latin. And even the report states that it's not to be used in criminal proceedings. And then Brennan said, well, go back and listen to the witness who testified that it was A-OK. And then Alessi said, no, he actually said it's not A-OK. So again, Brennan misstating everything. Now, I said I don't keep track of all of this, but because I don't do homework. But Jemima does. Defendant's motion in limine to present demonstrative exhibit based on Christina Henry's testimony in a talk, but still, it'll probably be on Discord later. So everything that's allowed in and. So she all the homework for me. It's nice to have good mods. That's how you get into the running for mod of the year without having to cheat.
Nobody cheated. I used the rules to my advantage. That's all.
Yeah, he cured dead people. The brain guy cured dead people, so he had way more talent than anyone else. Was a ham sandwich?
There was reference to a ham sandwich.
I could eat a ham sandwich. I got
You
a
know the
call from
saying.
the HOA because there's a guy coming to do service on my furnace tomorrow. So
Okay. I thought it was about the fence thing. I was like, get out of here.
no,
man.
I told her if he contacts her, she was like, oh, it's you this time. He always has something that he has to complain about. You know the type.
Sounds like it. He sounds like it.
Yeah, and it's always those things where you. And she was like, how is she supposed to make the HOA force you to not have leaves blow outside?
Better control where those leaves land.
Well, the fence thing is tomorrow I'll go and get some fiber cement boards and just rip off the ones that's on it and then screw in some new ones. It is in the Discord section for Karen Reed if you want to go look at it, because it's a little distorted. But thank you so much, Jemima. You're a peach. And I didn't understand what the two options were, either bingo or
Trivia?
something. Trivia. If you live stream with Baker multiple times, then you should be disqualified as mod of the year.
I disagree for several reasons. One of which, pretty much all of the mods live stream with you multiple times.
Brandon hasn't live streamed.
That's true. Brandon hasn't. But nobody's voting for Brandon for mod of the year. Let's just be real on that one. He's not in the running. Marissa disagrees as well.
Trivial shoot like, but how can we play that during an opening statement, because we can't answer the questions? Apparently the trivia is similar to words on stream, but you put in your own questions. But how do you run it while the stream is there? You just get kicked in the teeth doing voting. Brandon is such a good mod that he doesn't even claim his monthly membership chats.
That's true. I don't know if that makes you a good mod or not, but he doesn't claim them.
Oh, yeah, that's... Plant fan is having fun. That was the best joke I heard all day.
Taking the solo stand on that one, huh, Plim fan? Nice.
I want to be mod of the year on Val's channel. It would be the crowning jewel of my fake mod status. Could do it while on Verdict Watch. Yeah, it's just...
Yeah.
It's just if we needed something to make us not bite the table when Hank is doing his opening statements. But you're right. Then no bingo, Jemima has decreed.
She doesn't want you to play bingo, chat.
No. That's I was about to go out and buy a Lego set and give that away for the winner, but Jemima said...
Nope. She said... No.
She's been mod long enough that she is like me. Every question is answered with no.
No. Dave, stop it. Ugh.
I think of something bingo may be hard doing this case. Well, I know someone who is not... No. That's why we have a hardness expert on this trial. Yeah, Gemma, we're saying that's why she gets to decide that none of you can get to play bingo. We are appreciating her so much she gets to make the decisions.
And she chose that you all don't have to get to have fun.
Yeah.
Yeah.
So she's the killer of all the joy. We just wanted to make it a little more enjoyable, but and Danity doesn't want to do bingo, so...
Well, there you go.
Will we get to see the cannon this time? We can only hope.
That'd be awesome.
It's not fun
would be
being
awesome.
judges. Oh yeah, last time you had to figure out what the words were. That's the problem. But no, it's we can try and set up some trivia for Verdict Watch, because I don't want to speak out of turn, but I think Verdict Watch will also be more than 2 hours this time.
Oh, for sure.
Iris, you won the mod dance-off contest. So you are the dancing mod of the year. I still
Also,
love
she was
her.
the only contestant, but
No, Jamie could have participated, but she was in her one-person sleeping bag that the weird Scandinavians live in. Do I know the TV show Born? Yes, I do. Iris follows that show to learn Danish, and I showed her the Parliament building, so she knows where Birgitte Nyborg, the steps she walks up on. We could have gone inside and had a tour, but I thought, no, let's walk 5,000 miles in one day, because that's clearly what we did, according to Irish. But yes, I do know Born. Season 1 I watched. I think I started season 2, but didn't finish it.
Why are you pronouncing Borgen weird?
Because it's Born. It means castle. The castle. Because our parliament is in the former king's castle, a place called Christiansborg. And Borg means castle, and when you put en in the end of it, it means this specific castle. So it's the castle. You missed a museum and castle.
How did you miss a castle? Aren't they kind of big?
I don't know which castle she's talking about. But yeah, and which museum. I took her to see the royal stables.
Nice.
So she got to see all the white horses.
Goats are better, but I get it. That's cool.
No, we speak Danish.
Weirdly, it's not a language.
Could also do guesses on which witness will change their testimony from last time. Well, Jen McCabe will run away with that one. Can I see my transcript?
Oh, she's good. She's gonna have to see the transcript every time.
Oh, Rosenborg. Yeah, which is Rose Castle. That's where the crown jewels are. That's a fun little castle, right next to the lifeguards barracks, or as we call them, the girl guard, because none of us like them. Do you have the same with those fancy pants regiments that everyone just hates them?
So for us, it's like the National Guard, right? The guys that are part-time, quote unquote.
Yeah, weekend soldiers.
We make fun of them. Yeah. We call it.
Well, we do have that.
Girls.
We have what's called the Home Guard, which is weekend soldiers where you can sign up and regulate traffic at county fairs and stuff like that.
Yeah.
They get deployed as well, but we still make fun of them. Say they
Same.
Yeah, they can't exercise after midday because they're too drunk at that time and stuff like that. Which they're not. They are actually doing a big job. I was on the board of people who approved people to join them when I was in politics. But the lifeguard is one of those everyone hates just because they think they're special. It's kind of like MPs. No one likes an MP.
Nobody likes an MP. Nobody. And of course, y'all, it's just silly rivalry. It's not like we're not talking crap about. Well, I mean, we are talking crap, but you know what I'm saying. No, this is Alice and her baby Dottie. the chat has decided her name is Dottie, so we're going to go with it. And she was born Thursday. Catalina, Mrs. Valhalla, took one look at her yesterday and told me I was silly and that she wasn't close. So she got evicted out of the nursing stall for now. But she will get there eventually.
Our lifeguard has the big bearskins as well. They did so the last time as well, Dave, whenever you catch up to us.
Yeah, the jury went last time. This time they're trying to get Karen Reed to go as well.
Yeah. Can you tell chat what you found out last night about the name of one of your goats?
Which one?
What does Babs mean in Danish?
Oh, Babs, who is the one goat that looks like Catalina, right? Apparently, Babs in Danish means tits, and that's
no, it's one tit.
One tit.
Babs,
one tit.
Babs is one. Babsa is two.
So Babsa is two.
Yeah,
that's interesting. So yeah, apparently my goat's name is Tit in Danish.
In Ireland, we have part-time soldiers called the FCA. Some people says this means fools carrying arms.
Everybody's got those little,
yeah,
pick on
and it's just fun rivalry. We have, because the Navy took over the guard at the King's Castle when the lifeguard had their jubilee, and we of course claim that's the only time that the king have been safe. And that's the only time he heard good music, because it was the naval band that played. And then we fight about that. And it's fun. And
it's fun.
And then we talk to them about how to shine your boots, because they cheat and they lacquer their shoes. We water, spit shine them.
Yeah.
And the first time takes like 8 hours just to get the shine on them. And then you have to keep it. It's such a, and now and again, some weirdo would you play a lot of weird places, and someone will hit it with a stick or walk into you, so they scuff them, and then you have to scrape it off and start over, and it's just building layers upon layers of shoe shine. It's such a real. That's the non-fun part of being in a
dress unit.
Yeah, dress part of the military.
Yeah. In the infantry, we didn't have it that extreme. Some guys would go to that extreme, right? But as long as you had a pretty good shine, you weren't going to get in trouble or anything. We didn't have those mirror finishes most of the time because we worked for a living.
I got shit talked to when I was deployed, because I spit shined my well, I didn't spit shine, but I had a high gleam on my shoes, because it's just second nature when you're normally always shining them. So both my parade boots and my work boots, I kept to the same standard, and I didn't spit shine them and build up the layers of but they were always nice looking. And one time my major came over and said, "You can't wear those shoes to this parade." I said, "Why? Look at mine." I said, "Well, you can just learn how to be a."
You're gonna make everybody look bad, Baker. What are you doing, man?
That's just the way to do it. We are on a regular break. It's 11:11, so it's probably going to be a 45-minute break, and then back for 5 minutes, and then lunch.
Well, actually, doesn't Brennan have to be at Stoughton at noon? So they're not going to start at noon.
I don't. Well, Lally can take over. He's co-chair.
Okay, I'm here for it.
I don't know.
I don't either. She didn't tell us. She didn't tell us what time they're going to be back.
The darker goats pop out kids so much faster. Is that true?
I think that's a racism.
Oh, that's a racism. Well,
I think
I
it's
for
a
one
racism.
don't see color, so I can't be racist. I am colorblind. I love when I said that to Jamie, and she was, "Are you colorblind?" Yes, Jamie, I'm colorblind. I miss her innocence.
Oh, Jamie. I wish she didn't hate me.
Yeah, she doesn't want to be on stream when you're here.
Ever. If I'm coming, she is not here ever. And I'm starting to take it personal, Jamie. It's starting to hurt my feelings. I'm a sensitive guy.
I don't know. I sent her the link and she just sent back, It's a co-stream with Val.
She said no.
No, I'm not gonna join. She hasn't been in chat all day.
I'm telling you, man.
Yeah, I don't know where the beef stems from, but it's real.
I don't either. I wish I knew so I could fix it. I love you, Jamie. Stop hating me. I miss you.
It doesn't work on her. I'm sad to say. I have tried to be lovey-dovey with her for 2.5 years now. She punched me multiple times.
I heard, man. She's an abuser.
I love that those little goats are just jumping on all 4 legs because they can't really figure out how to do it.
She's only like 4 or 5 days old or something. She's getting there, though. She's starting to get active. She's a little cutie.
When you left her alone yesterday, oh my God, she was crying.
Oh, yeah. That got loud fast. Usually they'll just curl up and lay down, but she wasn't having any of that. I do kind of like that she's in there alone too, because when there's other goats in there, it gets crowded, right? And like,
yeah,
they start to get a little timid, right? Because they'll get bumped around a little bit more. But her being there with just her mom right now, she's got full access to the whole stall, and she's just been hopping all over the place. I love it. I love it.
Not that it's the same, but my grandson apparently doesn't want to sleep right now because he's figured out how to do the. So he's just constantly doing smacking noises. Oh, how nice! He's just blowing you kisses. It's like
He's
I really
learning.
want him to stop blowing me kisses and start sleeping. That's funny how they work.
The circle of life, y'all. The circle of life.
Well, Tim, good luck. How long have they been on break now? We're taking our midday break, and they've been gone for 22 minutes. What?
That's not
Don't they have a toilet at the same building?
Yeah, but Bev's currently got that occupied.
Yeah, there's a smell of weed and White Claw coming out of that stall.
Doink. Her and Doink are hanging out.
Yeah. Oh, I bet you he has the really, really cheap skunk.
I don't know. His mommy makes money, doesn't she?
No, she's a gold digger. She has a rich husband that she got divorced from.
I thought she was a prominent attorney.
Well, she claims she is. She had a new theory on the case 2 days ago, where she was. They got in an argument. She drove off. Then he kicked the car and she backed up and hit him. That's how it happened. So again, no proof of anything. And she's a lawyer and she's just talking out her behind.
It checks out. That's what the Commonwealth is doing.
Yeah, it's just I'll put it on Twitter. And then they'll go and say, you don't say anything that Aiden doesn't say. Aiden streams at 2 or 3 a.m. my time. I never watch Aiden streams. I don't know what Aiden is saying. I haven't even seen if he has reported from court today.
The last I watched the Ronnie stream. I watched the juror stream, but I haven't watched.
Yeah.
I haven't watched her boy. Otherwise, why aren't you loading yet?
Nancy Grace pulls the same stuff. Yeah, when she left the Delphi case before cross-examination, and then it just went out and said, "Yeah, this is what the witness said." No, that's not. Oh, OnlyFans just stopped for a second, so I was. Are we going? Are we going on lunch break or?
I would assume so. This one.
Someone in Lawn and Crim says 15 minutes mean half an hour. Yep.
Well, she brought them all up there to discuss scheduling and then just dipped out without informing us what the schedule was.
Yeah. It couldn't get through even a second episode of the new Karen Reed document series. She's just too unlikable. And then Karen might not be likable, but she's not guilty.
Bazinga! That's funny.
Haha, AJ denying association with the blogger. I love that they hate Aiden so much that they call him the blogger because, we can't mention his name. It's like Voldemort for them. Voldemort is the evil guy in Harry Potter, if you haven't watched it.
Thanks. Appreciate it.
Yeah, he kills Harry's parents. Spoiler alert.
You can't just spoil a 7-part movie like that, man. 8-part movie. You just throw in spoiler alerts? That's terrible.
Yeah, I know it's a big thing in it. That it's a big revelation in the end. Maybe the beginning.
It's in the very beginning. So right there.
Hank by himself is by far smarter than anyone on the defense team. He will be the downfall of Karen V.S. Reed. King Warrior Soldier seems angry.
He is by far the smartest person in that room. Just ask him. He'll tell you.
Yeah.
What is Swayzer? What is Swayzer?
What? Swayzer? That's
how? Oh my goodness!
Someone hasn't been around long enough.
Do you remember any description as far as the size of these men?
Yeah, I remember the size of them. I know, I could tell by the Swayzer who the one was. You know, by meeting him different times up there at Paula's, I knew Swayzer is. Get that word right, Swayzer.
Okay. I don't know what that word means, so I'm sorry.
Oh, his style, his walk, his talk.
Okay.
It's amazing.
I've muted myself. Oh, someone is having a bad day.
Oh, wow. Danny T, calm down.
That's what Hank does to you. Baker, you let Brev savor her claw in peace. She has enough stress as is trying to help cover for the stage without you trying to rush her to finish her only enjoyment in life. Well, if she just rushed through all of it, just denied, as we know she will, then she could have more claws.
Right?
She could be done by today and we can take tomorrow off.
She could get real drunk. Everybody's having a pretty rough day.
Well, Ralphie has a lot of Swayzer.
Get it, Ralphie.
She's been slapping that ass.
Without context.
Doink the Clown has breaking news.
Of course he does.
Karen Reed's legal team was scolded related to a motion. Okay, I'm going to read this in Doink words. And you make of it what you want. Karen Reed's legal team was scolded related to a motion from the state to remove Arca from her witness list for the upcoming April 1st, 2025, retrial in the matter of John O'Keefe's death. Judge Canoni found Reed's lawyers committed deliberate acts of omission and made material misrepresentation statements to the court, and in turn, it appears that not only will Alan Jackson be removed from Reed's witness list, but
that's not true.
At the same time, Jackson himself might be removed from the case.
That's not true.
We are now at sidebar with Karen Reed and her lawyers, ex parte, talking with Judge Canoni. This is very serious, folks. First of all, he was never on her witness list. Second of all, he wasn't removed. Doinky man, doink. You're an idiot.
He is. He is.
Just so frustrating, this whole thing. I just love that we're taking a mid-morning break that has now lasted more than half an hour. And we don't know if they are on lunch break, because they could just as well just go on lunch break, because Beverly Bev, and she's going to come back and she's going to be annoyed, and then she's going to go on break in 15 minutes. Does female goats headbutt as well?
Yes. Yes. All goats headbutt.
I thought it was just males to assert dominance.
No, goats are actually matriarchal, right? So the leader of the goat herd is almost always a female goat. They're the herd boss. The boys are just there for, protection and funsies. But the female goat is almost always the one that's leading the pack. They're all very aggressive.
Do you have to assert dominance, or do they accept that when you go on the walks and stuff like that you are the leader?
So I'm looked at as like a weird goat, right? Because I don't headbutt, right? I don't play with my goats rough, and they're not allowed to play with me rough, right? You don't get to headbutt me. That's not allowed. So I'm a weird goat that gives love. So they all accept me as part of the herd. I don't know that I would be the leader per se, but they know that I have the squirt bottle too. So I do have some authority.
Is that what Mrs. Valhalla calls it? The squirt bottle?
Giggity. They really hate the squirt bottle.
You talk about me, then you wake me up from my mid-morning weed nap. Hello, Doink the Clown. Does anyone watch Meat Eater? I don't know what that is.
No, I'm not sure what that is.
Please pass the pepper. Free Karen Reed. Appreciate our independent journalist. Karen is all of us. Corruption. I headbutt. Please pass. Yes, this is actually because, again, I cover tons of cases. I don't normally deep dive like we do in this case, but this is so glaringly obvious that if Karen Reed didn't have the biggest set of balls this size of Suez, she would just have been railroaded into a plea agreement.
Oh, yeah.
Now, this lady said, I'm going to take my entire life and auction it off, sell it, do whatever I have just to fight for justice. And you have to appreciate that.
It's a ballsy move.
Yeah. Especially with the odds stacked against you like she has in this one.
And continuing to further get stacked against her.
All right, so Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
okay.
Martin Weinberg. If, in fact, the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, I believe that whoever it is that is appearing for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. Monday. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be to you 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right, thank you very much. Does it make sense for me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan?
Thank you.
Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
Yes, it's the appeal of the habeas petition to remove charges 1 and 3 that the 5 jury members who have come forward all claim they were unanimous not guilty on.
All right, Mr. Schillinger, I have no idea how this works, so why don't you tell us?
Sure. So, as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown, and the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which. At the same time, the Commonwealth is...
Bev, stop blowing into the microphone. We can't hear what he's saying.
Obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40, how many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure.
Before she leaves the bench, so it would make sense if they could, but again, they can't schedule the First Circuit. So, and she has that 1 year deadline that she has to keep. Not because she wants Karen to be found guilty, but that's the rule. She has to do it within a year because she can't just throw it, because it's not the defense, it's not the state's fault, so they should do it. I don't know if it's for the day. I couldn't believe it should be from the day, because she said that they needed to hunker down and as I look at the chart from Jemima, there's like 26 outstanding motions still, so probably should get a move on. I think someone, I think Valhalla mentioned it earlier maybe, someone has told him to not do it all the time. That's staring. Yeah, face the fan. It's 1 year from the end of the previous trial. But if you have to factor in with half days and birthdays and long weekends and drunkenness, it was 8 weeks the last time. When did the case end? It ended in June 20...
I have no idea. June 25th, 24th?
I think, yeah, June 23rd, 24th, somewhere around there. So let's just count backwards. It's gonna take 8 weeks. That's the last time, plus maybe a week of deliberation. The absolute latest would be around April 21st.
What do you get when you cross a rabbit and a goat? You get a hair in your milk. That's pretty good. I like.
All right. So we'll see everybody back here, not tomorrow, but Thursday morning at 9 o'clock. That'll give you time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will. Thank you, Your Honor.
Okay. So see you Thursday. All right. Thank you, everybody.
So half day again.
Yeah.
Yeah, she asked for full days, how many full days, but Bev doesn't do full days. Well,
that happened quickly.
We had our morning break, that was 30 minutes. We did our pre-show, that was 10 minutes. So 2 hours in court today is what Bev could string along. 2 effing hours. We have 28 outstanding motions still to go if I
There's no
count
way this
correctly.
starts on time. There's no way.
She said this morning that we had a lot to do, and then was it set to be half a day? No, apparently it's going to be Thursday now.
And no afternoon session now.
Yeah, no afternoon, so I can remove my afternoon session. Can one of the mods look if the Pew Pew Plow Plow case is going, because then I can catch up on that one.
Can I just remove from StreamYard my stream from the StreamYard here? Will that work, I wonder?
I can go in and totally remove it, so...
I wonder if it'll still be in my studio. Thanks, Bev. You just complicated our streaming. Ugh.
Oh yeah, Turtle Boy. No, I don't think Turtle Boy normally isn't streamed.
In
So,
Stoughton?
Yeah.
Yeah.
You need to delete it on YouTube if you didn't do that.
Yeah.
But I don't know. I can look at and see if there's some.
I think we can just delete there.
You can just do it in StreamYard if you say delete, and then they ask delete on YouTube as well.
Oh, okay.
Don't see any of the big ones carrying it.
Oh. Well, I can't because you deleted it, which is fine.
Oh.
I can't access it anymore.
Then,
That's fine.
you
I
have to
can
do
just
it on
from
YouTube.
here.
Sorry.
Yeah, yeah. No worries.
Then,
No worries.
then you're gonna have one of those ghost streams that keep popping up, and you're thinking, I don't do anything about that.
I guess we can just turn it private for now.
And
Maybe I should I'll just delete it.
Doesn't look like the plow pew pew trial is going today. So,
which also means that I need to set up a goat stream.
Yeah, then I can redirect to your goat stream.
I like that idea.
Just looking at to see if I can find anywhere they're showing aid and. Have you Jesus, it's only 4:30.
She really messed up everybody's schedule here with this nonsense.
Yeah, that's why can't I find that one? Oh, probably because it's live, you idiot. No, it is. Is it live?
Competent, they're able to make that decision.
Well, Baker is the loudest Taylor. It's on! No, I'm not reading chat, but when I look at this side, I'm not looking at chat, Marissa. And now my Discord keeps pinging because the mods are getting angry and saying, it's on. Well, Hella, what do we think about today? Do we have any...
I think to sum it up, it's pretty safe to say that Bev's bias is getting to the point where it's hard to not see. And
he said not see, not the other
see,
word from Germany.
Not see. As soon as I said it, I was like, that sounded bad. And I think we can all vouch for the fact that Brennan's a lying liar that lies. He's quite the creature.
I'm just horrified that she started the day like she did by yelling and screaming bloody murder based on a lie from Hank Brennan, Special Prosecutor. I think that's absolutely disgusting, and you can tell she was just yelling because she fell for it.
Oh yeah. She's done that almost every session so far. She's basically come in, yelled at the defense, made them look bad based on something that Brennan lied about, and has no qualms about doing it in front of the public. She knows it's being live streamed. She's doing it intentionally. She has no problem taking sidebars to address every other thing so that nobody knows about it. But she wants the entire world to know that these slimy defense lawyers are wrong.
Were Danes the main Vikings or all the Scandies? The Norwegian and the Danes were the ones who went west. The Swedes were so weak they had to go and fight in Russia. So we were all Vikings, and we were the best Vikings, of course, because we had the biggest tracts of land, and we rolled over England so much that they have a place a part of England that was called the Dane law because Danish law was applicable. And just because we are so great at war, we invaded parts of France. Well, we didn't. We joined up and got given parts of Normandy is the northern people's land, is what it means. They were given that when some Vikings started working for the French king and beating other Vikings. So the Normans that invaded England in 1066 was descendants of Danish Vikings. So even though the English king beat a Viking army before the battle at Hastings, it was descendants of Danish people who then beat England's army by shooting the king in the eye with an arrow, taking over the country. So today, England should be Danish because it's Danish blood that runs through the royalty. I'm just claiming facts here.
History out of budget, y'all. History out of budget.
It's facts. You can't. I would love to argue facts, but you can't argue facts because the Normans, William the Bastard, later William the Conqueror, was a descendant of the Normans. The Normans meet the men from the north. So,
where was Rollo from?
Danish.
Was he?
Yeah, Rollo. Yeah.
Rollo was technically a king of Normandy at one point, right?
Well, he was a duke under the king. So, but he had very liberal rights, and he got christened and promised the king that he would fight the Vikings because the Frenchies couldn't figure out how to fight us, so they had to hire us to fight ourselves. Imagine that, French people not fighting their own wars.
Weird.
Je suis Hollandais. Je suis fini. If it wasn't because they, it would be such a bad flag, it would have been white. Which is really stupid because French people is actually one of the most winning nations in history, but we just forgot that entire time with Napoleon was around kicking everyone's butt.
They had a pretty good navy there for a while, the French. They were
And the navy was always shit.
The
Because
French
that's
navy?
the only way. Yeah, the only way the British didn't lose to Napoleon was because they could blockade his harbors. So that's why they had all the battles on land. They could win with Les Grandes Armées, but they couldn't win on the seas.
Around that 1776 era, their navy was pretty okay in the Americans' book.
Well, they help you out, but that's the Normans were from Normandy, yes, but Normandy has the name from the Normans. Normans means men from the north, which is Vikings. That's why Normandy is actually North country. British and Spanish had good navies, yes.
Well, the British had the best navy like of all time up until,
We actually had
airplane
until
carriers.
1807 when the Brits did the world's first terror bombardment was actually in Copenhagen with the Brits. They bombed Copenhagen, set it on fire. And then we lost a big battle to them in 1807 where they took our entire navy. And we had the largest navy in the world at that time. But because it was the Danish people, we were a big sea power because you have that strait between Denmark and Sweden. You have Helsingborg Castle where Hamlet apparently is. They had cannons there, and we owned that part of Sweden, so we had cannons there, and we could shoot everyone. So they had to pay toll, and that we built a massive navy so we could fight the stupid Swedes. So
Outstanding.
We have I showed of course our pride, the part of Copenhagen that we built with the POWs from Sweden, because They shouldn't just be hanging around eating. They can do a little work while they're
Listen,
POWs.
I'm drawing the line at forced labor. All right, I'm not touching forced labor.
It's a lovely place of Copenhagen that they built for us.
Oh, that's terrible.
I'm going to end this. I'm going to redirect over to, we're going to pick up the Plow Plow Pew Pew case, and apparently it's about to end today. That's what they expected yesterday. So we're going to do that. Valhalla is going to redirect to his goaty goats, and
yes,
we'll see how everything goes. And I'll just be back after a short breako el bio. Valhalla.
And we'll be back for Thursday.
We'll be back for Thursday, which is perfect because then I can end this case, and then tomorrow I can make that stupid fence so that stupid idiot can shut his stupid mouth. All of you, thank you so much for joining. We will be back together on Thursday, and both of us will be back on our own channel in 2 minutes.
Momentarily. Yeah.
See you later.